decision and the debate that has taken place in that regard, given the concessions that have been made. What we would do is draw the Court's attention to a decision of the Constitutional Court, which we say effectively endorses the dictum of JAFTA the Berg River case, and the decision in question is Sichal versus the President, RSA and others, 2013-9, Butterworth's Constitutional Law Reports 1091cc. And that is authority which in our paragraph 27, which supports the dictum in Berg River. So, in the light of the concessions made, it seems to us that no purpose would be served further arguing that.
It's proper, Mr. Rosenberg.
As far as the rationality of the decision is concerned, that appears effectively also to have been conceded, certainly on behalf of Mr. Zuma, and it certainly seems to have been conceded inasmuch as it is accepted that the question of Mr. McCarthy's interference, such as it was on the question of the timing issue, the timing of the service of the indictment, was not a sufficient basis, not a rational basis for withdrawing the charges against Mr. Zuma. The argument on behalf of Mr. Zuma would accordingly appear to be that that decision could only be rational if a whole range of additional material is taken into account, Browse Mole, for example, being the most obvious example, and you have our submissions on that, and it appears to be accepted that the decision itself was based upon a much more confined reason, and it's not permissible or appropriate to go beyond the reasons given in order to assess the rationality.
Well, I'm afraid I think there'll be rounds 2 and 3 and 4
yes.
after this, Mr. Rosenberg.
Yes. So for that reason as well, it appears, as we read or understand the concessions made by both of the applicants in this matter, that the rationality of the decision, particularly or in addition, as far as the question of alleged misconduct based upon the timing of the service of the indictment, that too is an insufficient basis to justify or to qualify this decision as being rational.
No, that's not quite correct as I understand it. That's Mr. Kent's concession.
Yes.
Mr. Epstein's concession goes no further than 1795.
Yes.
As far as the timing of the indictment is concerned, that Mr. Epstein's argument is that that in itself was an egregious abuse of prosecutorial power.
Yes. And the court has our submissions on that, and I don't propose to deal with it in any further detail beyond our.
Well, Mr. Rosenberg, I tell you what my problem is, and it's really a legal technical problem over and above the concession that's made. Let me just spell it out for you, and perhaps you can bring me to better insights. If, and I think it's almost inevitable, and the compelling conclusion is that they just didn't know what they were doing in making the decision. They chose the wrong empowering statute. They're vacillating versions of how it all occurred. For that basis, you knock it out on the Liebenberg principle. That ought to be dispositive. That is wide enough to encompass a rationality review simply because you're looking at all sorts of the wrong things. Now, if you said anything over and above that, for example, if that was dispositive, if you said, but in any event, the basis of the timing, which seems to have been the thrust of it, wouldn't have provided a basis, that may be obiter or it may be an add-on. Does it matter for your purposes? What rounds 2 and 3 occur is not up to us to decide.
It depends upon the approach that the court takes to the matter. We would make the submission that as far as reliance on the timing issue is concerned, for the reasons we've set out in our heads, and I don't propose to take the court through that, the timing issue is not a rational basis for the discontinuation of the prosecution. And we say that for a range of reasons that we've set out in our heads.
Well, if what my brother Kachalia put to you, let's assume, just for the moment, and I don't know what the value will be of the add-on, but if we were to find on the first basis that they used the wrong section, that encompasses rationality, and that in any event they're limited to the question of timing, it's not enough, and that in addition is the ground for setting it aside. Whatever the value of that is not something that we need to be concerned about at this stage.
I must accept that, and insofar as Justice Kachalia pointed out that the concession of the inadequacy of the timing issue as providing a rational basis for the decision wasn't entirely conceded by counsel on behalf of the NPA, I direct the court's attention to our submissions. It's not necessary to go through them as to why we contend, in fact, that timing issue doesn't provide a rational basis. And if the court would like me to go through the submissions on why that is the case.
No, we've debated that extensively, as you've heard.
Yes. And we would submit that obviously depending upon the approach that the court takes, it might decline to deal with that as being unnecessary. On the other hand, it might feel it's appropriate to deal with that, and if it does deal with that, we submit for a number of compelling reasons which have been debated in part. It can and ought to be found that the timing issue does not provide a rational basis for the withdrawal of the prosecution.
Yes.
As far as...
How much longer are you going to be, Mr. Rosenberg?
There's unfortunately not much more I can say. But what I would...
We're very pleased about that, Mr. Rosenberg.
What I would like to emphasize is that it appears to be accepted on behalf of Mr. Zuma's team that the consequence of the withdrawal of the charges is that, in fact, or the consequence of the setting aside of the withdrawal of the charges is the original decision to prosecute remains in place. It also appears to be accepted as being an appropriate issue to be dealt with in the order or judgment of this court, to direct that that is the case, and that it would then follow that the following steps normally would involve the reservice of the indictment.
You don't have any in principle.
We don't have any problem with that. That in fact, it would be salutary for that to be included, so the elements of uncertainty which have been floated around can be cleared up, and so that everyone can be under no misapprehension that it now follows that the prosecution goes ahead in the normal
And whatever processes are available to anybody.
that might involve reservice, and as Justice Leach had pointed out, reservice in order to provide for a fresh date for the next or following appearance. Those type of procedural steps can conveniently, it seems, be addressed, at least in part, in the judgment of this court, to clarify the kind of misunderstandings which have been suggested might arise, and which, if possible, ought to be avoided. As Justice...
One wouldn't need to make an order in that regard, though. One wouldn't need to make an order in that regard. It's never been an issue. It wasn't an issue before the court, al quo.
No,
it's not an issue as to what the procedures are, haven't been fully debated before us.
Yes, that is so, and we would suggest that the formulation and approach suggested by the presiding judge in this matter is the appropriate approach, and that's how far it ought to go.
Okay. I mean, all we'll do is we'll probably explain that in the body of a judgment as being accepted by everybody, and everybody will go forward on that basis.
As the court pleases, and in those circumstances we would ask that the appeals get the applications for leave get dismissed with cost. Everybody appears to accept that the costs of 3 counsel are warranted, and our submission it is,
Yes,
given
thank you.
the nature of the matter.
Mr. Epstein, perhaps we can just make sure we're not at odds in relation to exactly what it is that I mean, it seems both of you have accepted that in relation to the power that was exercised, that is a sufficient basis for setting aside the decision.
That is so.
As I understood the submissions that you were making while you were on your feet when we were discussing the statement by Mr. Mshe and what he took into account, you were intent on presenting an argument that said, well, he did take everything into account. But wouldn't you be pressed to accept that if timing is the only issue, that that's not sufficient?
If timing is the only issue.
If timing is the only issue.
If that's the only issue. But it's what was behind the timing, the purpose of the timing.
Well, that's something that has to be taken into account.
So timing itself doesn't affect the merits, doesn't affect the fair trial.
Yeah. All right. Okay. Well, I mean, I think we can probably circumscribe it on that basis. All right. Is there anything further?
I have no further submissions to make to damage my case any further.
Yes, okay. Mr. Kemp, nothing further, I would assume?
Justices, if I can just point out, I perhaps did not specifically answer something that Justice Kachalia put to me. I simply will answer that I do not accept that the written representations were accepted. They were all one process.
No, but sorry, maybe we should put to you what I put to Mr. Epstein before. You saying it all has to be taken into account, and when you make the representation, that has to be revisited.
Yes.
But timing on its own is not something that you say.
That is it. No. It was always our case that you have to read it with the other.
Yes.
Thank you.
Yes. Thank you to counsel. Judgment is reserved.